still needs to comply with the requirements of the doctrine, and they can't allow emissions greater than what the doctrine and sound science says. So several of these cases have been dismissed by district court judges, and basically what the judges are thinking is, or what they're saying is, I don't believe I have the power to do this. This is a legislative function. I need more guidance from the legislature as to what should be happening, and they don't believe that they have the ability to enforce the public trust doctrine. And you know, looking at case law, all the decisions that have come out, judges have the power to do this. They, just because it's true, the doctrine has never been applied to the atmosphere, but that doesn't mean the doctrine shouldn't and isn't applied to the atmosphere. It still provides this check on legislative and executive action that they're required to fall under. And convincing judges that they have this power, that they can take these bold steps, seems to be the most challenging part of these cases. And it's going to require a lot of thinking going forward in this effort as to how best to not only tell the story of climate change, but convince judges that they do have this power and they shouldn't be afraid of being overturned on appeal, because it's an important aspect of their role as judges to ensure that the other branches are fulfilling their legal obligations. And so I think that ongoing discussion about how best to convey that to judges and convince them that they have this power is an important part. And with that, I will turn it over to Professor Davidson.
Okay, why do judges have that power? And why do judges have that power, and why should they claim that power? I want to talk briefly about a second branch of the public trust doctrine. There's been reference made to the Justinian Institutes and to the chain of authority that derived from the Justinian Institutes that concerns common resources, resources that in their nature should be held commonly by the society. And so you have the Justinian Institutes, you have a great deal of English authority, and later you get to the Illinois Central case here in the United States, where they said the city of Chicago or the legislature of Illinois could not give away the entire Chicago harbor to one railroad corporation because all of the people had an interest in it. The Supreme Court couldn't have been overruling that legislative grant of power unless they were doing so on constitutional grounds. The nature of those constitutional grounds has stayed a little bit murky, but one aspect of public trust that we need to look at that hasn't been adequately looked at is a separate doctrine called the reserved powers doctrine. The reserved powers doctrine doesn't just focus on the resources, doesn't just focus on water and wildlife and air. It also focuses on time. And what the reserved powers doctrine focuses on is the limitation placed on each legislature in terms of the extent to which they can interfere with later legislatures' sovereignty. Those later legislatures deriving their sovereignty from us, from the later generations. And that tradition goes back just as far. Cicero talks about it, Lord Bacon talks about it. It shows up in the United States in Fletcher v. Peck, and it shows up in Illinois Central. In Illinois Central, the court doesn't just rely on this Justinian Institute's common resources idea. It also relies on a case called Newton v. Mahoning County, which is specifically about just the generational sovereignty, the legislative sovereignty over time. And what they recognize is that each generation and each legislature needs to have the ability to address the particular problems that come up for it. And when one legislature destroys that ability, either through passing some sort of permanent law, or in this case, actually destroying the resource, destroying a sovereign resource interferes with the ability of later generations to protect themselves. Global warming is an issue where this aspect of the public trust doctrine comes into highest relief. The scientists tell us about positive feedback loops, they tell us about tipping points. All of those involve irreversibility. If we as a people and our legislatures allow certain resources to be destroyed in an effectively irreversible manner, then we implicate this generational sovereignty reserved powers aspect of the public trust doctrine. When we focus on this intergenerational aspect of the doctrine, we're also in a better position to rebut the political question charges that come up. Political question charges are based upon the idea that the court is unelected. It's exercising counter-majoritarian problems. But if the particular constitutional protection we're interested in is protecting later generations, those later generations have no representation in the present political process. The court is no more anti-majoritarian than the legislative branch or the executive branch. And it's the court's recognized responsibility to protect discrete and insular minorities, to protect unrepresented groups in the exercise of their constitutional rights. Professor Douglas Grant wrote one of the best articles exploring this particular dimension of the public trust doctrine, and I encourage people to look it up and apply it in their own practices. In terms of convincing the judges that they have this authority, it's appropriate. If you look at the major cases that all of us learn in law school, if you look at PIELC v. Connecticut, when they're deciding what rights should be recognized as a matter of substantive due process, they say you're supposed to recognize rights that are implicit in the concept of ordered liberty. That's what this sort of limitation on the sovereign powers of any one generation is about, protecting long-term ordered liberty and democracy. And the other part is in PIELC v. Connecticut, they say that rights should be recognized as a matter of substantive due process if they're rooted in traditions, the traditions and conscience of the people. Again, that's why all of this history that goes back through the English common law, goes back to Roman times, goes back into almost every society for both the reserved powers doctrine and the public trust doctrine, shows that these ideas are rooted in the traditions and conscience of the people. The idea that we share the air, the atmosphere, that's a common heritage is so rooted in all of our culture, in our poetry, in our literature, and in our law, that it's hard to ignore it. Similarly, when the court's looking at when it's appropriate to exercise strict scrutiny, to interfere with the other branches, to apply the closest judicial analysis. Some of the most frequently invoked standards come from footnote 4 of Caroline Products. And what Caroline Products says is that the courts it's appropriate for the courts to intervene when the normal channels of legislative change have been choked off. Well, when you destroy the atmosphere, you've choked off the ability of later generations to control this resource, to control policy in an equal way. You've interfered with them in that way. And that's also where they say, when you have discrete and insular minorities, when you have politically unrepresented minorities, that's a case where traditionally courts are allowed to intervene. The last point I want to make for those of you who are practicing in this field is to consider changing the notion of the trust resources that should be protected. In general, what we've said is that trust resources are things that are valuable to us. Wildlife, water, bridges sometimes, the airwaves. And those things have to be held in common. They can't be privatized. They can't be destroyed because we all have a shared interest in those things. We also all have a shared interest in things that are hazardous and dangerous. On the one hand, we have the duty to protect the goose that lays the golden egg, whether that's an old-growth forest or salmon fishery. At the same time, to use fairy tale language again, we have shared interest in the control of the dragon that's lived for 1,000 years underneath the castle, that comes out and destroys things. In the case of fossil fuels, we're looking at both. It's a goose that lays a golden egg for a little while. It's also a dragon, and we recognize that. And just like you don't want nuclear weapons to be privatized, there's some sort of reverse hazard trust that should control those. When you're dealing with fossil fuels, those should be treated as some sort of reverse hazard trust as well. And in terms of jurisprudential philosophy, when you accept that those dangerous resources are also a subject of trust, it becomes easier to avoid problems around the state action doctrine and things like that complicate some of these cases. What the people on this panel are doing, the ideas that they brought up, the realities that they gradually develop in the legal community mindset, and the actual concrete actions that they're taking, the manifestation that's going on, is some of the most encouraging work that I think exists in our society right now. And I hope we further it as creatively and as diligently as we possibly can.